Ministry of Health guidelines. Thank you very much. I'm doing very exciting research with the university law clinics in Kenya. And it is this research that informs my presentation, which can go on until the sun sets. But given the guidelines we have just received, I have exactly 3 slides, a full paper which we can discuss over tea and over lunch, and I'll also over email and further interactions. So what I'll emphasize are mainly 3 aspects of my paper, which focuses on the sorts of challenges that our university law clinics are facing in their quest for promoting access to justice. We have been very loud in this conference about legal aid, about access to justice, and especially about the role that universities are playing in access to justice, given that we're actually being hosted by a university that is active in offering legal aid. So in the first part of my paper, I try to locate this access to justice role that we have given ourselves as law schools, as training institutions. And surprisingly so, I find it difficult to locate this role within the legislative setting that we have for our universities and also for our law schools, so that the legal framework actually emphasizes the role of the university merely as a teaching and a research institution. So much so that this role that we're talking about very loudly here is actually one that we allocate ourselves as schools, mainly because I think of the generosity of our hearts, that we have so much legal knowledge, and then our neighbors have so little legal knowledge, and we decide, yes, we are going to share it with them. And so it's actually a duty we've taken upon ourselves, arising out of, well, moral underpinnings. And also because of the practical reality of it, that, well, law schools need to practice their legal skills, the students need to be taught how to deal with clients, and then you have this category of clients that people who need legal advice. So it's actually pragmatic that, well, you come together, those who have excess of legal knowledge and those who have a deficit of it. But we do not really have the legal and institutional frameworks that are supportive towards legal aid clinics and law schools offering legal aid to society. So I link this discussion then to the sorts of activities that our clinics are offering and are having. In my research and in my paper, I share statistics of the kinds of activities that law schools are offering, and most of these are actually outreach activities. So any indigent person who has problems with representation cannot find their solution within our law schools. So we only reach out to those who want to hear about the law, but then in practice can do nothing about it after. So the activities are limited towards legal literacy. And what then I move on to is an experience that many clinics have. When they set out, when they're launched with a lot of pomp, a lot of circumstance, a lot of conferences like this one. I don't mean to be pessimistic, but I want to read out to you an experience that one clinic shared with me in a focus group discussion. It's an excerpt. And then this clinic, this experience was repeated in discussions with other clinics that I encountered. And allow me to read it out to you, although it is here on the slide. Well, the clinic was there, but it was barely functional. But you left. That was 2015, right? But the president in 2016 was leading it. They were crawling. They were trying. Then the year she left, it died like nobody's business. In 2017, people stopped attending meetings. There were no projects. The leadership had so many fourth-year students who were stressed with their dissertations. Bad planning, they didn't even care. So an excerpt from a discussion that you find reverberates among other clinics. They experience seasons of dormancy. And these seasons, I attribute them later on in my paper to very specific challenges that the clinics encounter. And I could go one challenge after another, sounding like a prophetess of doom, but I will not. What I will do is to categorize these challenges according to the levels at which they occur. Now, what was interesting in that research is that at clinic level, at law school level, there's a lot of understanding and support from the school leadership because they understand that clinics are useful for pedagogy and they're also useful in promoting access to justice. So they understand the twin roles of clinics. And so there's a level of commitment that you see in law school staff and in law students in going out into communities, sharing legal knowledge. However, this commitment does not seem to be extended at the university level because law schools exist within a university setting. And I think it seems to be that within that university setting is where the key decisions are made. So as we saw in the initial slide, which allow me to take you back to, since the university framework focuses on teaching and research as the key objectives of the university, clinics therefore have been relegated to the role of extracurricular activities. So most clinics that go into communities actually volunteer students and staff. So as clubs, as student associations, they are removed from the key priorities of the university. So here means that the level of funding they will receive is much lower. Staff allocation is more of having a patron oversee the work of students, be they 150. They might not have sufficient space, and I admit that running a clinic within a university is a very expensive venture, and it's akin to running a law firm within the institution. So it requires a level of commitment, which translates into financial support as well, so that clinics can have sufficient supervision by qualified staff and advocates. They can have the space, they can have facilities that they require to be able to achieve their legal aid goals. So towards the end of my paper then, I address, of course, each of the specific challenges, but my key proposal, especially in an avenue like this, is to encourage those at university level, well, to see how law schools can create a buy-in within their institutions and other departments, help them realize the value of clinics so that then they can be able to generate a higher level of commitment towards their clinics and therefore be more supportive towards clinic activity. And then for a forum like this, external stakeholders work consistently and work very well with clinics. Actually, many university law clinics are dependent on partner institutions for support. Many clinics work with NGOs, CSO, Civil Society, Law Society of Kenya, because it is from these institutions that they can get support, they can get practicing advocates who have a like mind and similar goals. So I encourage and I actually recommend that key stakeholders and also like-minded institutions strengthen the support that they have for university law clinics beyond moral support. So to have a support that is tangible, to be more generous in terms of their support, financial support, and also other ways in which they can be more supportive towards university law clinics. And then an overview of the paper is also the need for a stronger legislative and institutional placement for clinics within our institutions. Thank you very much.
All right, thank you, Anna. We'll move on swiftly to Dr. Rogers Odhiambo, who is presenting on a similar topic about the place of law schools and clinical legal education and legal aid. Dr. Rogers.
Thank you, everyone. I think Anna has touched on some of the issues that I'd wanted us to discuss this morning. My presentation, actually, my paper was divided into 4 parts, but I'm not going to get into that. I'd wanted first to look at the overview of the question on access to justice, and also to look at the challenges, both legal and structural challenges that present itself that hinder people from accessing justice within the system. But also, which is the main focus of my paper discussion is with regard to placing access to justice at the heart of legal education. So what I'm trying to say is that this need for us to, time has come for, in my view, that legal education providers need to fill the gaps that we have within the justice in terms of the challenges that we have, whether structural or legal. But I'll not get into those challenges and the structural challenges and legal challenges. But to look at the idea of access to justice and trying to look at how the same could be enhanced through clinical legal education initiatives. And therefore, what clinical education does is to expose students to the practical application of law and put them in the position of using this in order to, for their legal knowledge and to respond to real life issues. Address people's problems, and therefore that is very critical. And therefore, the development of this type of education or legal education is therefore designed to meet multiple goals. Number one is to provide students, is to provide high quality teaching and research. Number two is to deliver social justice by being responsive to justice problems that have been highlighted in as far as Kenya is concerned, and of course, but thirdly, something here which I would like us to share, that if, and I'm trying to quote it directly, that if it is true that the function of the law school is to approach the study of law from the theoretical and scholarly side, it is equally true that it must not become so academic so as to separate itself from the profession which it represents and for the practice of which it undertakes to train its students. So the question about law clinics is not something new. It's something that started earlier on in other jurisdictions, especially US and others, countries like Canada and the UK. But the approach to the training of lawyers ought to be similar to the clinical approach used in the training of medical students or medical practitioners. That's the suggestion that is being made here. I know there are challenges, for example, like that Anna has talked about, but if we are serious that we want to position ourselves as legal education providers in order for us to have a role in society and to challenge the status quo, then we must therefore call for the reforms within the legal education sector so that we make sure that just as doctors, medical doctors trained with real patients, that we also need to have a system that would allow our students also to deal with real life issues out there. Because in my view, what this will also do, will also instill discipline, and of course, apart from discipline, professionalism, and also the need for them to understand the value of the legal profession. Because if you look at the legal profession generally, then one of the things that, okay, the most important thing in my view is the question of justice, to deal with the issues of justice in society. And therefore, if we introduce these students early enough to understand what justice means and the problems out there, then they'll be able to be innovative and be able to deal with the problem. So the skills cannot be appreciated if they are introduced without engaging the pathos of the human issues. that the lawyers encounters with representing clients. So for me, this is very critical. So therefore, the legal clinics would be able to, or legal education, would be like, if you may, like laboratories where these, the lawyers that we train hone their skills and their knowledge under the supervision of course, of practitioners. So we need to make emphasis in as far as this is concerned, and of course take practical steps in doing that. Of course, this will also call for reforms. I know there will be issues with regard to how this is going to be implemented, and precisely that's the kind of discussion that I would want to us to discuss, so that at least this is made into the practicality of this is actually addressed. But you see, I'm just trying to make a case for legal education to be embedded. And the point I'm making is that I'm not suggesting that it should just be an activity of a law school, but it should be actually structured, done in a structured manner, that it becomes a fully fledged unit within the law school, and therefore should also be part of the curriculum that students are taken through, and they must also be graded for that kind of activity. So it's not something that they would, okay, for those who are interested in pro bono services, but it's a program just like other programs, and if it were possible, I'm glad we have Mary here from the Council for Legal Education, that it should also be one of the mandatory units, just like we have the 16 units that the Council insists that all legal providers must provide for them even to get the license. So clinical education, in my view, should also be put mandatory, that every student should be able to go through. And this also resolves the issues of, you talk to these students, especially when they come to law school first year. So you ask them, so why did you choose to study law? So it's either daddy told me to come and study law, or it was mommy's idea, or I think law is a prestigious thing, or this money. In fact, money is the most, 3/4 of students will tell you that they came to law school because they think lawyers make a lot of money, and there's money to be made in the profession. Or it's either a friend, or they think it's a prestigious course to do. So I think it might be able to deal with those kind of issues. Then students are exposed to justice issues at the very early age. And this might help them to understand the essence of the legal profession, which is to deal with the questions of justice. Yes, so I'm just winding up. I've been told that time is. So a program, of course, that teaches through direct experience of lawyering under the supervision of practicing lawyers or teachers is very important and very crucial in terms of addressing or trying to advance social justice issues or public interest issues in society. And therefore, that is what I have to say in as far as making a case to embed the whole program of CLE within the education sector, within the legal curriculum, so that I know there's also the question of, universities' missions generally released to the core missions, teaching and research. But I think a time has come that law school providers must also confront, the challenges in society. And as a result, community service should therefore be part of the core missions for universities. I have a recommendation is as far as this should actually be done in terms of, not in terms of financing, but in terms of the structure that this ought to take. And of course, I began by saying that there needs to be organization such that we need to set the administrative, the structure and the foundation of the law, of the clinical legal education within the law school as a fully fledged department, but also in terms of curriculum programs that it should be in the curriculum, and students should be graded, and this should be able to, okay, as part of whatever. Then it should also be accessible. There is need to be, for it to be accessible. So the question of accessibility is also very important, so that members of the community should be located in such a way that members of the community are able to access, and also so that then it will be able to meet its need. I think that's what I have to say very briefly in as far as that proposal is concerned. Thank you.
Thank you, Rogers. Thank you, Rogers. We seem, for those of us from the Legal Academy, we seem to have similar topics, and maybe we need to have a meeting outside so that we can discuss how we are moving forward. Be that as it may, we are going to move on to the next presenter, and that is going to be Brian Sang. So let's hear from him. Then just to let you know, we are going to combine the two sessions that we were supposed to have so that we save on time and hopefully go for lunch. And then when we come back, we can move forward. We have quite some time in the afternoon. I know there are people who have questions. So please, if you may note down your questions, then in the afternoon, we can have a question and answer session where we can discuss more of the issues. Yes, Brian?
All right. All right, good morning. My topic today is on gender discrimination in access to justice in Kenya, enhancing the agency of women in securing effective legal aid. The paper is structured into 4 parts, and because much has been said about these topics, I will be fairly brisk in my motions, and will try to avoid belaboring points which have already been made previously. So I will begin with the introduction to this topic. The problematic in particular concerns the provisions of the Legal Aid Act 2016. Despite all its good intentions to provide access to legal aid and assistance to persons in need, there is a sense in which the provisions of the Legal Aid Act, they tend to be worded in gender-neutral terms. The effect of using gender-neutral words was discussed yesterday, I think, in the presentation by Commissioner Catherine Muma. And in brief, what that effect is that it tends to take a presumption that men and women are formally equal in legal terms. However, when you look at the practicalities of the situations of women in this country, it's such that they tend to be less economically well able. They have restricted freedom of engagement. They have less opportunities to gain a knowledge of the law, and therefore, by taking the position that men and women are formally equal in legal terms, we lose the aspect of substantive equality and equity in terms of social justice and inclusivity of women. So, to the provisions of the Legal Aid Act, there's a typo there. It's supposed to be Section 4, of the Legal Aid Act, which sets out the general principles which should guide the National Legal Aid Service in the provision of legal aid services in this country. There it recognizes the principles of gender equality, gender equity, inclusiveness, and non-discrimination as general principles that should guide the National Legal Aid Service in the performance of its functions. However, when we look at the actual the principles the provisions which operationalize the delivery of legal aid to persons in need, when you look at the provisions relating to eligibility for legal aid, when you look at the provisions concerning access to state-funded legal aid, you find that gender is not one of the key considerations. So there's a sense in which the gender aspect within the Act has not been prioritized to the extent to which ordinarily it should. And my argument is that even though a superficial reading of the Legal Aid Act would seem to suggest that it is gender neutral, that it recognizes the general principles of gender equality and equity, that does not often reflect the reality. Now, this gap, the gap between the appearance and the reality, has caused certain actors, particularly within the civil service and people interested in law reform, to actually begin a conversation, an ongoing conversation about the need for gender perspectives to be deliberately ingrained into the access to justice discourse in this country. And that is the conception, at the conceptualization stage. And then how do we operationalize that? Is that the argument is made that there is a need to actively promote gender-sensitive approaches to legal aid delivery. So I will skip to the point where we are looking at what are the gender-based determinants of access to justice. There are a number of key determinants which play a role in determining the extent to which women in particular have access to justice. And this I have categorized into three key determinants. The first key determinant concerns gender and inaccessibility of justice. Inaccessibility comes in three ways. Justice may be inaccessible to women because they have limited knowledge of the law. The explanation is fairly simple. Most women who are impoverished and marginalized, they tend to work longer hours than their male counterparts. So most of the time, these women are engaged in casual work, where they go to look for work on a day-to-day basis. They get back to their homes, and then they have to step back into the traditional gender roles. They have to be the primary carers for young children. They are the homemakers. They are the people who are preparing the food. So in that context, you can see that they do not have as much time to engage with the law. Their educational and awareness possibilities are restricted in that regard. And so access to justice may be inaccessible to them because they have limited knowledge of the law. It may also be inaccessible by reason of geographical remoteness. We listened yesterday to a comment by one of the conference participants who told us that she usually goes all the way to Garissa to provide legal aid and assistance. That's a good example of a place that is very, geographically remote. And in those areas, a study was done, I think in 2017, a gentleman known as Sharmit Lamba wrote about a topographical survey of court stations in this country. And he found that there are certain areas, particularly in the northern region of Kenya, whereby the distance between a court user and a court station may be as far as 400 kilometers away. Now, if you factor in the costs related to transport, the costs related to accommodation, the time spent away from home, and this is, a low-income woman, justice becomes inaccessible by reason of geographical remoteness. It may also be inaccessible due to unaffordability of costs. Famously, the legal profession is unreachable for most people of the low-income bracket because legal services tend to be expensive, and without any type of financial assistance, legal services are inaccessible to most people, and particularly women who tend to be poorer than their male counterparts. Another gender-based determinant of access to justice is the question of the inefficiencies of legal processes. In most cases, most of you are lawyers who regularly attend court. There are moments where cases tend to be pushed forward. Matters take longer. So the issue of delay, the issue of difficulties in the administration of with filing, with files disappearing. This also creates obstacles. And in certain cases, particularly in cases dealing with divorce, cases dealing with child custody and child maintenance, the weaker party, which in many cases is the woman, the files tend to disappear at the moment when a favorable ruling is about to be given in there to them. And I won't get into the details of that, but those are some of the inefficiencies of the legal process, which create very imposing hindrances to women and make it difficult for them to obtain justice. Another gender-based determinant is the question of discriminatory outcomes in redress mechanisms. Women may go to court seeking justice for issues such as marital asset division. They may get unfavorable outcomes. All right, now I will very briefly look at what are the responses that have been given to gender-based barriers to access to justice. There has been legislative reform. Important legislation such as the Marriage Act, the Matrimonial Property Act, the Protection Against Domestic Violence Act. These are important legislative developments. However, when we look at the judicial reception, there have been very inconsistent judicial decisions, particularly in the area of marital property division and adult spousal maintenance of children. I won't go into the details of that. The other aspect is the national policies on legal aid. We have the National Legal Aid and Awareness Policy, which alludes to gender in a very generalistic manner. It doesn't give specifics. And when we look at the National Legal Aid Action Plan, the word gender is used only very few times. So that's a key pointer to the way in which gender is not given priority. There have been important organizational and institutional initiatives to respond to the issue of gender-based discrimination by groups such as FIDA Kenya, Kituo cha Sheria, and Egerton University's Faculty of Law Legal Aid Project, which is part of this event. So now, because I'm running out of time, I will move to conclude and say that thus far, in terms of Kenya's legal aid delivery regime, the issue of gender has not been prioritized to the extent that we would expect. And what the effect of this is that very many women continue to face imposing barriers to equal access to justice. There is therefore a need for piecemeal reform to the Legal Aid Act in order to include the issue of gender discrimination in the operational provisions rather than as general principles of application. And without further ado, I will conclude my presentation on that point. Thank you very much.
All right, thank you, Brian. We'll move on to the next presenter, and that is going to be Ronald Omedo.
Distinguished ladies and gentlemen, all protocol observed, good afternoon. Good afternoon once more. My name is Ronald Kihali. I am a student of Egerton University, actually former student. I just finished recently. And I just want to say before I begin my paper that I've been privileged to be a part of this program. As a student, I've done it in 4th year, so it's been a very helpful opportunity for me. And so today I've been given the opportunity to present on a paper, and my paper is focusing on access to justice in the context of the Legal Aid Act. I'm analyzing the Legal Aid Act, just like the previous speaker, Dr. Sang, has been talking about, only that while he has been focusing on gender, I'm going to be focusing on the general provisions of the Act and whether they have been efficient or effective in terms of promoting access to justice. So without further ado, my paper is quite bulky, so I cannot focus on those other principles because it begins by talking about access to justice in the general context, which most of the previous speakers have been able to talk about, so I'll not really delve into that issue. I'll go straight to the Legal Aid Act and discuss its efficacy. Now, I'll be looking at the progressive provisions of the Act. At the same time, I'll be looking at the weaknesses of the Act, and then I'll be able to recommend or provide some recommendations, and I think that might form a subject of some discussion, given that you have Ms. Flora from the National Legal Aid Service. So yeah, I think she'll be able to comment on some of those discussions. Now, I think most of the previous speakers have talked about the National Legal Aid Service, and I think I also find it to be a very progressive provision of the Act because it not only gives the functions of the National Legal Aid Service, but it also gives the mandate and the power of the National Legal Aid Service, which generally shall be to ensure that there's access to justice for all, as has been talked about. And there's also the issue of the National Legal Aid Fund, which is a very fundamental provision because it means that the service is well funded. That means that people can access justice without having to worry about the affordability of the legal services that they're going to receive. Now, moving on swiftly to a progressive that I found was to be problematic, especially as a former student, is the fact that one of the functions of the service is to develop programs for legal aid education. My argument is that this has not been really implemented. Admittedly, we have legal aid clinics, and they have been very helpful. But my argument is that we need to, just like Dr. Rogers has said, we need to entrench legal aid education in our system, in our curriculum. And I think if you look at the Legal Aid Act, it stipulates that the Council of Legal Education should partner with the National Legal Aid Service to ensure that there's legal aid entrenched in the curriculum of law students. And I think this is important. Training is very important. Before you send students to give legal advice, I think training is quite important so that they know how to handle clients, they know how to provide legal service, and it will be a boost to the fundamental principles of legal aid that they have already studied or they have already covered. Now, another provision of the Legal Aid Act 2016 that I found to be a bit problematic was the fact that legal aid services cannot be provided to a person whose case doesn't seem to have a probability of success. So I don't know what you think about that, but I found a problem with that because Generally, lawyers are supposed to take cases regardless of the merits of a case, regardless of the credibility of a case, regardless of the likelihood of the probability of success of that case. So I think that maybe Ms. Flora will talk about that, but I think that that section should be amended so that we can have legal aid service, the National Legal Aid Service, taking cases, any nature of a case, regardless of whether that case has a likelihood of success or not. It is only through that that we can ensure that everybody has access to justice. Now, my second last point is the fact that the National Legal Aid Service is the body that has the mandate to review its own decisions. This is in the context regarding the fact that if you apply for a legal aid from the National Legal Aid Service, and the National Legal Aid Service refuses, because they have the discretion to refuse, if you look at the Act, if they refuse to grant you that legal aid, you can seek review from the National Legal Aid Service. Now, the problem with that is that, my argument is that this brings about a potential conflict of interest. I believe that we should have an independent institution established by the National Legal Aid Service that should be able to review the decisions of the National Legal Aid Service. Because if you're going to seek review of the decisions from the decision maker, I think that that would be a potential conflict of interest. So maybe, again, Ms. Flora would have to address that. But I found that as a potential weakness of the Act. And just finally, which is actually a very, very fundamental weakness, is the fact that the Act has envisaged that there would be regulations. If you look at the National Legal Aid Act, there are so many gaps in the Act, but the Act clearly stipulates that most of these gaps will be covered by regulations. For example, accreditation of National Legal Aid Service providers. It has not been provided for the criteria for that accreditation. The Act stipulates that it will be provided for in the regulations. So the problem with that is that there are no regulations. I was actually trying to look for that. There are no regulations. So maybe my recommendation, my argument would be that we need these recommendations because there's a lot of lacuna in the law. There are a lot of gaps, there are a lot of ambiguities, there are a lot of conflicts, and I think that if we have these regulations, because what does it mean? What criteria has the National Legal Aid Service been using all these 4 years since the Legal Aid Act was enacted? So in conclusion, my argument is that it's commendable that we have the National Legal Aid Act. At least we have a legislative framework for legal aid. We have the institutional framework for legal aid through the National Legal Aid Service. But my recommendation would be that, especially that part about regulations. I think if we have those regulations, most of these gaps that we are talking about, or most people have been talking about, would be able to be covered in those regulations. Otherwise, thank you very much for giving me your ear and have a very good afternoon.
All right, so I've been informed that I should mention this small fact. Ronald is amongst the pioneer students graduating from the Faculty of Law, Egerton University. So I think he did a good job. He's also amongst the students who work at the Legal Aid Clinic, so it's good to see that at least they are dealing with such things. Thank you, Ronald. All right, so we'll move on to the next presentation. This one will be virtual from Anne. So I don't know if Anne is ready. And the IT guys over there, are you guys good to go? All right, so we'll give Anne 10 minutes before we move on to the next presentation. Thank you.
Okay, thank you for the opportunity. Good afternoon, ladies and gents. My name is Anne-Marie Gamburo. I am a fourth-year student at Strathmore Law School and a member of the Strathmore Law Clinic. So this will be my third and probably my final year at the Strathmore Law Clinic. The Strathmore Law Clinic is a student-run organization that was founded in 2016. And when I talk about student-run, I mean that the bulk of the projects and the activities that we carry out are done by the students themselves. They're conceptualized by the students themselves. And then we have the lecturers and our school come and support us, guide us, and provide us with resources to be able to carry out the projects that we conceptualized. And so we are dedicated to furthering access to justice through the provision of legal information to all persons, of course, with a greater focus to those who cannot afford these legal services. And how we do this is through outreach projects and research projects. So for this year, obviously due to COVID-19, a lot of our projects had to be researched and most of them had to be moved virtually. And one of the papers we sought to write about was how to enhance access to justice in Kenya. And so I will not go too much into the paper, but I will focus on the main issue and the recommendations that were made. So the main issue is something that most of the speakers have reiterated. They've said that we do have a transformative constitution. We do have a constitution that sought to ordain a shift from past ethical crisis, repression to a better Kenya and a better future that was characterized by renewed ethical values, a robust Bill of Rights, and of course, citizen emancipation. And in keeping with the theme, the right to access to justice is one of these very fundamental rights. And we do recognize that the government has tried to take various steps to enhance access to justice in Kenya. However, we have almost stagnated because the numbers are rising. The number of people who are entwined within the justice system, the number of people who cannot access the justice system is increasing as years go by. And we also do recognize that NGOs have really tried their best, but because of limitations of human resource, of resources and financial resources, they cannot be able to cater for everyone. And therefore, we need to step in as students, we need to step in as lawyers, we need to take that stand. And just to quote Justice Majanja, who said something that is very fundamental, is that without access to justice, the objective of the Constitution, which is to build a society founded upon the rule of law, dignity, social justice, democracy, cannot be achieved if it is within this legal, cannot be achieved because it is within these legal processes that the rights and fundamental freedoms are realized and protected. And so without access to justice, then how are we to realize all the rights in the Constitution? And that's why we wrote this paper. And so this paper recognizes that the role should not be left to the government alone, but in civic society, but should also extend to students. It should also extend to lawyers. And what you discover and what Ms. Kotonya has echoed is that you may have a clinic, we may establish these clinics in Kenya, but how do we make them sustainable? How do we make students want to sign up? And how do we make students want to stay within the clinic? And which is why we look at incentivizing these students, why we discuss incentivize pro bono. And we are focusing on two key players, the students and the lawyers. So my starting point will obviously be the students and the young people in the field. And we cannot appear in court, but we can do a number of things. We can create legal awareness, and legal awareness is a very important facet of access to justice, because how does someone realize that they need to go to court if they cannot even know that they have been wronged in the first place? And number two, students can be very instrumental when it comes to research work. We can come in and support the already existing structures by being researchers, by working in collaboration with other law clinics, law firms, lawyers, NGOs, private firms. It's very possible. And so I want to back up my claim with what the Strathmore Law Clinic has been doing in the past 2 years, that these things that we're talking about, these credit systems, this making clinical education, introducing them into our schools, is something that we are already doing, and we want to show how it is very possible and it is very feasible. It just needs us to start, take the first step. And so in the past 2 years, we have done quite a number of projects, almost 9 projects. And what we noticed is that I will use 2 projects to highlight these 2 important points that I gave you. So the first one is Sheria Mashinani project that was done in collaboration with an organization called Crime Sipoa. And what we did is we went and got youth from 13 villages in Kibera, and our members, our own clinicians, students of the Strathmore Law School, were able to train them on human rights issues, labor law issues. And once we trained them, the next phase, just to ensure that there would be sustainability, was for them to go and train people within their villages. And so we would have sessions or town hall meetings where people would come, they discuss their issues, they bring forward their cases, and then we were there just as quality control, just to make sure what they're being taught is what we actually taught in the first place, that it is in line with the law. And what this did for our students, first of all, was give them that practical aspect, that practical application of the law. And secondly, we were exposed to things we did not know existed. And so what you realize during clinical work is that we as students probably live in a bubble. We are shielded. We do not know the harsh realities that go on out there. We come into law school thinking, I want to make money, I want to be rich. But once you join the clinic, you're exposed to these harsh realities, then your mindset is changed. And so we went into Kibera, we were able to train these students, we were able to ensure that there's going to be sustainability. And you get a young child, a young boy, someone my age coming to tell you, a police officer told them, it is very normal for you to be arrested 3 times a year. It is very normal for this to happen. And you wonder, are you not aware of the law? Have we been taking it for granted? And so these are the steps we are trying, these are the corrections, or rather, these are the gaps that we are trying to fill. Another project that we've been looking at is that second years and third years are attached to lawyers, and they provide legal advice. We write legal briefs for clients. We are trained how to carry out interviews, how to conduct interviews. This happens after class. And then you go, you conduct an interview, you're attached to an advocate of the High Court of Kenya for indemnity purposes. And then you end up writing a brief. You have it checked by your lecturer, checked by the advocate, and then you have a document that is presentable. You're training students from a very young age to be exposed to the practical side of law, to be able to apply what they learn in class into the real life. And Strathmore has taken an extra step into even trying to get indemnity insurance for the clinic, because it would be better if students would be able to give this legal advice, be indemnified, have this insurance, as opposed to just having lawyers. The lawyers would just be there to guide us, to, make sure that what we're producing is quality work. So these are things that are actually happening. And this year, the school sought to create a credit system, make the law clinic, let's call it an elective, to make it an elective, to make people be graded on it. And what has happened was it has encouraged students to join the clinic. And the more students join the clinic, the more numbers we have. So from 2016, we've moved to having around 50 people in the clinic to around now 80 people. And we continue to grow each year. And that's how we're ensuring that students join and students stay. We also have award systems that we have within the clinic. They could be monetary, financial, and also we have the school coming in to also give awards. And these are steps we have taken to encourage students to join the clinic and stay within the clinic. And I know the concern is, then why shouldn't students do this out of the goodness of their hearts? Well, the reality is we're all human beings, and we all need that extra push to be able to be exposed to something in order for you to know that it's good for you. And so once a student gets into the clinic, then they have their minds molded, they have their minds built, they have their mindset changed. We move from I want to make money to I want to make a difference in Kenya. And that's what we have been trying to do. And that's why we're making a case for having clinics within institutions, institutionalizing clinics, as my fellow presenters have said. We need to have them entrenched into our systems, into our curriculums. The CLE needs to step in. And then on top of all that, we need to introduce clinical methods of teaching into our schools and make clinics, support clinics, because they can really make a difference in this country. Thank you.
All right, thank you very much, Anne. We'll move on to our next presenter. Please, ladies and gentlemen, if you have any questions, of course, just note them down. And then in the afternoon, I think we have saved quite a bit of time. We'll be able to engage in exchange of knowledge and, of course, question and answer sessions. So our next presenter is going to be Ndindi Ng'ang'a.
Good afternoon, everyone. Oh my goodness, good afternoon, everyone. Oh, there we go. My name is Ndindi Ng'ang'a. My name is Ndindi Ng'ang'a. I'm an advocate of 8 years experience and also the founder and CEO of Legal Ease Africa. It gives me extreme pleasure to be here today, and are all protocols observed. It is an honor to be before each and every one of you this day. And it's also, it gives me extreme pleasure to be here on this final day of the 16 days of activism against gender-based violence. We have been commemorating various forms of gender-based violence since the 25th of November. And today we are commemorating the Human Rights Day. So it gives me extreme pleasure to be here, to be making this presentation today. On a day when we are supposed to think about human rights, we're supposed to think and deliberate about human rights, and I believe that with all my heart, as we have all discussed, legal rights are human rights. Our paper is titled "The Salient Actors Involved in Enhancing Access to Justice and Legal Aid." Ooh, my voice is shaking a little bit because I ran from the other side. So I will focus on two significant salient actors that I work with, that is advocates and sign language interpreters. We also work with psychosocial counselors. In fact, they are constantly telling us that everybody needs to go for counseling because we go through various kinds of, should I call them traumas? Various experiences in our lives. But we only think, no, counseling is for guys who have gone through extreme forms of trauma. But anyway, just to re-emphasize that counseling is for everybody, and more so for persons who are coming into the legal system to seek access to justice. This paper was written by myself and Sylvia Muturi. Sylvia Muturi is a deaf whisperer or sign language interpreter. Allow me to allow Sylvia to teach us a few phrases in sign language. How many here can actually sign, apart from 3? How many here can actually sign? All right, we have 3, good. All right, why don't you look to your neighbor and say hi to them? No words. No. Hi, good. Sylvia, could you kindly show us the sign language for how are you feeling today? How are you? How are you feeling today? Today. All right, how are you? How are you feeling today? Ask your neighbor that. And they have to respond back to you, please, kindly. How are you? So if you want, you can smile, perhaps happy, smile. If you're a little tired, perhaps, what's a sign for tired? Oh, tired. All right. If you're sad, perhaps, sad. So tell them, go ahead and communicate to your friend, how are you feeling today? Respond, by the way, respond. No, you're not supposed to. No words, people, no words. I hear words being used. No, you are signing. So there's sad, there's happy, there's tired. They're tired. I'd like you to imagine. Thank you so much, Sylvia. Let's give her a hand. I'd like you to imagine what happens to a person who is hard of hearing when they are going through the justice system. What happens when a person is arrested? Normal scenario. They are handcuffed, right? So how is a person who is hard of hearing, who communicates with their hands, supposed to communicate what they are feeling or communicate something when they are handcuffed? Just think about it. You and I can say, no, it's your mimi, niwache, mama yangu. No, what happens when you cannot communicate because you're handcuffed or you're muzzled? Think about that. Think about when we are trying to communicate aspects to do with legal aid to a person who's hard of hearing, who has to look at you in the eye to try and figure out what are you trying to say when they're trying to read your lips, but now we are all fully masked. Some of these challenges Sylvia has shared with me. I do not know how to sign. I know how to sign 1 or 2 things, but that's about it. But Sylvia has, even when she wrote this paper, when we co-wrote this paper, my heart really sank when she asked that question. What happens do we train our paralegals, for example, who are supposed to go out and assist persons who assist persons, indigent persons, vulnerable persons in accessing justice within the legal justice system. Are they trained on how to sign or how to assist? Are they aware? Are we aware? I mean, I can tell you many stories of when I have been in court. I've been an advocate for 8 years. When we have been in court and the judicial officers sometimes are a little impatient, like, come on, let's do this quickly. There's no interpreter, all right, moving on. What happens when they have to wait, a person has to wait for an interpreter to come to the police, to get to the police station before they understand why they are being arrested? Or we have to wait, a matter has to be adjourned for weeks on end because we are up in Garissa and an interpreter has to be sourced from a very far location. When we discuss legal aid and accessibility, these are some of the key challenges that at times we don't see them, and that's why we call ourselves the salient actors, sign language interpreters. Let's be honest about this. A lot still remains to be done. If a deaf person qualifies for legal aid, the state needs to provide a competent sign language interpreter, because a deaf person cannot communicate even with we advocates. I struggle myself to understand, and perhaps at times we write it down. But even in that writing down, we lose time and we lose that accessibility, that complete accessibility. When we discuss about the juveniles, for example, children who are in contact or in conflict with the law, depending on where you actually encounter them, there are hardly any juvenile justice system workers who are sensitized on how to deal with various disabilities, maybe perhaps except from a personal interest or from goodwill. We need to impact discussions with police officers, advocates, judicial officers, children officers, on how to cater and to care without discrimination to persons who are accessing the legal justice system. Once a deaf child is detained in the juvenile system, there is no special education designed for them in their natural language, which is the Kenyan Sign Language. There remains a gap on how to make the key stakeholders in the justice system held accountable in ensuring that the deaf person can access justice. We need to raise awareness with paralegals that sign language is the preferred means of communication. Failure to have an interpreter or captioned visual media, including video recordings, is a violation, and I repeat, is a violation of linguistic human rights for the deaf people. Currently, there are inadequate Kenyan Sign Language interpreters, and courtrooms for the normal human being can be patronizing and intimidating, how much so for a person who can only communicate using sign language. Article 48 has been re-emphasized within this conference, but believe it or not, Article 48 also includes persons who are hard of hearing, persons who have various disabilities. And access to justice is further guaranteed by Articles 49, 50, and 51, providing for the rights of arrested persons, fair hearing, and rights of persons who are detained, held in custody, or imprisoned, respectively. In other words, what we're saying is that everyone, when we talk about all, it is all. It is everybody. And that is the case that Sylvia put forward. We started a platform known as Legal Ease Africa. Legal Ease is a play on the word legalese. Legalese is formal, technical, legal jargon. Therefore, Legal Ease Africa is the opposite of legalese. We are all about information sharing and accessibility to the law. We aim to make the law easier to all. That's a bit of a challenge for most advocates. Last week, I had the privilege of giving a talk to the Rotaract Club Hallingham, And I posed the question, which I also discussed with Professor Mbote, about can lawyers be humanistic? Do we have the humane nature in us to actually handle cases? And when I posed that question, everybody was like, no, no, no. Advocates are, what's the word that came to your mind? Be honest. It's okay. I can take it. Heartless. Oh my gosh. Heartless, yes? Bare-knuckled. Hard tackling. Sorry? Money. There we go. I was waiting for that one. Money-minded. None of you said humane. None of you said soft. What is that? Humane. What's that? Oh, I like that. Oh, true. I introduced myself last weekend, which I also have been grappling around for the past few days. I confided to Professor Mbote that she caused me last night to stay awake. I woke up at 1 a.m. thinking to myself, oh my goodness, have I been sucked into a system that we just do not consider? Because we can come to this conference all week long, but when we go out there, we are facing cases every single day. Are we humane enough to actually talk about legal aid, accessibility to justice? I was introduced to the concept of humanitarianism. I will read to you the definition of humanitarianism. Humanitarianism, I'm trying to scroll really fast because I know I'm out of time. Humanitarianism, goodness me, and then technology decides, you know what? I will not be humane to you today. There we go. Humanitarianism is an active belief in the value of human life, whereby humans practice benevolent treatment and provide assistance to other humans in order to improve the conditions of humanity. In order to do what? Improve the conditions of humanity. I ask you, isn't that what we are discussing at this conference? Isn't that what we are trying to advance? At the very heart of legal aid is all about improving the conditions of humanity through legal assistance. I resonate with a lot of the presenters that we should change how we think about legal aid. Article 52 of the Constitution gives accused persons the right to be represented in trials. I like how Amnesty International put it, for how else can a judgment be pronounced fair when one party has superior legal counsel at their disposal and the other has none? One of the ways in which we advocates actually carry out this legal humanitarianism is how we conduct ourselves in court. I've had various discussions with lawyers about how to actually watch brief. Watching brief is explained as a brief held by an advocate to follow a case on behalf of a client, and that is because the prosecutors carry the case. They carry the case on behalf of the state. Most advocates do not. There's a lot of confusion about whether we should actually watch brief. But of course, there has been a very good precedent all the way to the Court of Appeal that we can actually watch brief. And even the Victim Protection Act comes in to actually support us that we can actually watch brief, which is another way of enhancing justice by actually offering legal assistance. So therefore, in conclusion, what am I saying? What's our strategy? We need to pay specific focus on strengthening the capacity of advocates, sign language interpreters, the salient actors, I call them, through capacity building in order to handle specialized cases and ultimately enhance access to justice and legal aid. We need to actually change our mind, think about what am I doing as an advocate? Am I only going for the big cases? You know, I always ask myself, we're over 14,000 advocates, and we have how many in Nairobi, all practicing in Nairobi, all hunting for the very same big advocates, big clients. So when I tell them I'm going out to Garissa, I always get very weird eyes, like, what are you lacking in your life? I'm like, no, we have clients all over. The issue about public good and legal humanitarianism is worldwide. We need to offer training programs to paralegals. We need to train advocates, not just the usual training, the continuous professional development programs, and we come in and we get a point or two and then we go home. We need to actually change our perceptions about legal aid. In fact, one of my friends calls it, we have an unconscious bias towards legal aid. We need to train all duty bearers on what exactly is legal aid. And I submit to you that legal aid is all about legal humanitarianism. Thank you very much.
All right. Things to ponder about. I didn't know anything about sign language, so, but I think I need to learn. Thank you, Dindi, for that. Seems we have to really unpack what access to justice means and what legal aid is. We'll have another virtual presentation, this time round from Professor Tom Ojienda. So I believe he's with us. So if you may please pay attention to him. Prof, if you may keep it to 10 minutes, that would be nice. Thank you.
Thank you very much. I will stay muted. I've followed 4 presentations by Dr. Rogers Odhiambo, who was on point on the role of universities in legal aid, and largely reflects on what I did as the first chair of the legal aid clinic at the School of Law, Moi University. And I've also listened to the very brilliant presentation of Ronald Omedo, who has spoken to the shortcomings of the 2016 Act, the Legal Aid Act 2016, Act number 6, and specifically on the questions of identifying cases of those who should be represented, and basically on various aspects of what I think would infringe Article 27 of the Constitution. I must say that I am used to the structure where those who come first, but I think in your schedule today, those who come first seem to come last, because I was supposed to have presented first at 11 a.m., but it is now 1 p.m. I hope next time the team will stick to its program. Now, I have a 34-page paper that I have shared with the team, and I believe that it would be impossible to present the contents of my paper titled Viability of Legal Aid as a Human Right within that time frame. I have sought to engage in a comparative exercise, and my paper therefore compares the legal aid scheme in Kenya and the scheme in the United Kingdom. This is deliberate. It is deliberate because I understand both systems from a practical perspective, not just as a legal practitioner of law, but because I was one of the initiators of the Rift Valley Law Society Legal Aid Project in Nakuru, and also the first chair of the Legal Aid Clinic at the School of Law, Moi University. And I have also, during my short sojourn in the UK, lived with solicitors who offered legal aid, and basically was part of, for a while, I would accompany them to their offices to offer legal aid. So I know that legal aid forms a very substantive part of practice in the UK, and you have lawyers who just focus on legal aid and are paid fees by government. So it is important as a starting point to look at a jurisdiction that we can look to in seeking to strengthen our legislation. The title to my presentation is deliberate. If legal aid is elevated or is looked at as a human right, and probably, as you will see in my recommendations, if the Constitution is amended to make legal aid a human right, then it will create an obligation on the part of the state to fund legal aid for every person who requires legal aid, and to ensure that Article 27 makes sense with respect to legal aid. By interrogating the human rights perspective of legal policy and policy framework on legal aid in Kenya and the UK, the paper considers theoretical and practical aspects of the current legal and policy framework on legal aid in Kenya. Indeed, neither the Constitution nor the Legal Aid Act is expressive that legal aid is a human right, and that is why this discourse is important to me. However, a concept of legal aid as a human right can be gleaned from the Bill of Rights under Chapter 4, and specifically, if you look at Articles 10.2b, Articles 19.2, and 28 of the Constitution, it is apparent that legal aid is a matter of human rights. It is also a matter of social justice, equity, because it addresses those who are not able to afford legal services. It's also about inclusiveness. It's about equality, non-discrimination. Those are aspects covered by Article 27. It also addresses protection of the marginalized and destitute, and the preservation of human dignity of individuals and communities. Closely, if you look at Article 48 of the Constitution and Article 52G and H of the Constitution, legal aid is equally about access to justice.
Okay, Prof. Agenda, we can't hear you.
Was muted.
Yes, I think he got
Yes.
back on.
Yes. So I was submitting that in matters such as family law matters or matrimonial P&A matters, or in judicial review matters and constitutional petitions, parties will be left out. One, because some of these matters are neither civil nor criminal in nature. And also secondly, because we have a weak legal framework that seems to lean towards pure civil matters and that create an elaborate and deliberately difficult process that precedes all applications in forma pauperis, as they call them. These applications that allow admission to the scheme. So the Act should facilitate, as opposed to stopping individuals from accessing legal aid, in keeping with Article 27 of the Constitution. And as I argue in the paper, to do so would be best served if legal aid is recognized as a human right. Let me go straight to a case that I've analyzed at page 23 of my presentation, the case of David Macharia, Njoroge, and Republic, where the High Court initially in this decision, Judge Okwany found that because a party had sought special damages of 179,000 shillings, that party did not qualify for legal aid. Now, the Court of Appeal in David Macharia and Njoroge and Republic case emphasized that the legal aid is only available to persons charged with capital offenses, and limits representation to accused persons charged with capital offenses at the state's expense. So it is obvious that clearly and this, I'm alive to the fact that the state has to spend to afford legal services to indigent members who deserve legal services. But clearly, the framework should allow an easier access. And that is why I compare the case of the David's case to the Jason Nyabuto Kembero versus Safaricom Limited case that I referred to earlier on. In this case, the High Court, Judge Okwany, dismissed an application to institute a suit by a pauper who had claimed special damages of 191,519 for breach of contract, stating that he did not qualify as a pauper because he had expended a sum of 191,519. And the appeal court upheld that argument. For the judge argued that under Order 33, Rule 1(2) of the Civil Procedure Rules, a person had to satisfy the court first that they were indeed paupers. In this case, the applicant had expended sums of money on telephone conversations, email communications, fare and accommodation, and did not qualify as a pauper. Now, the problem that this poses is that it makes it difficult for true paupers to qualify or to jump the first hurdle of qualification. And that is why a human rights approach, or if legal aid is recognized as a human right, then straight away, individuals who deserve or who feel that they deserve legal assistance would easily access this kind of assistance. Now, and through that, Article 50, Subarticle 2G and H of the Constitution would be complied with, because you cannot talk of a fair trial and a fair process within the civil and criminal law landscape unless you have legal representation. And as Anne said, unless the person initially knows that they have a right, because it is only if you know that you have a right that you can then seek to enforce that right or to ensure that it is achieved. Now, the second weakness of the Legal Aid Act 2016, as I've said, is that it seems to give a lot of latitude to other bodies to determine whether or not you or a party deserves legal aid. And the question of funding is therefore constricted. If the Constitution elevates legal aid as a human right, then that would solve the question of funding. It would also solve the question of non-governmental cooperation, either intra or inter-cooperation between government and non-governmental organizations in the first case. Also, cooperation between other organizations, for instance, like the Law Society of Kenya and FIDA, in providing legal aid to specific sectors. It would also lead the growth and the funding of other organizations that exist to provide legal aid. Ladies and gentlemen, that feeds therefore into what is envisaged under Article 159(2)(c) and 3 of the Constitution. A proper legal and policy framework on legal aid has to be certain, available, and comprehensible to all consumers of legal aid. And if the Constitution recognizes legal aid as a human right, then it will create deliberate actions on the part of government and ensure that there are vibrant institutions that provide the kind of work that Anne and other presenters are speaking to. They will provide organizations and bodies, national bodies, that will respond to the need for all forms of legal aid. That is advisory, consultative, and other forms of court appearances, and even other civil forms, including things like conveyancing. And that is why that would strengthen the weak legal framework that exists under Act 6 of 2016. In the UK, for instance, we would go out there, log in, do 2 hours of legal aid services. People would be calling in advice, would attract some fee for the solicitor I was living with, but at the same time, it enhances the ability of the advocates or the lawyers sitting in office to give advice. Of course, in the UK, there is sufficient civility because I hope I'm there. Am I there? I hope I'm audible. Hello, am I audible, please?
Prof, we can hear you. Continue.
Yes, thank you so much. So that a human right, elevating a legal aid as a human right would elevate the framework and the consideration of the state to ensure that consumers of justice would access legal aid in all its forms and would access information that would empower them to know when they require legal aid. Now, I have, because I know that there's a time question, I propose in my paper, and this is, because it borrows largely from the practice in the UK, where legal aid, first and foremost, is a government-funded enterprise across the board and covers both civil and criminal matters. And that is why we propose that it be expressly expanded to include judicial review, to include petitions, to include family or P&A matters. That's one. Number two, the codification of legal aid should recognize the equal access to legal aid of both gender. I have had a lot of talk of people who are marginalized, people who are disadvantaged. There's nothing like that. In fact, the beneficiaries of legal aid are mainly from the female gender. The majority of people who go to court, the majority of people who die first are men anyway. And you find that those to whom estates are left are usually the females or the mothers. I don't buy the argument that the female gender is disadvantaged, whether in family or otherwise. It is more a question of knowledge, because when they know their rights, they would go to court. Organizations like FIDA, for instance, are skewed towards offering legal aid to the female gender and not to male gender. More women will go to FIDA than men, because men usually solve their problems at home. They just stay at home and cry over their problems. Now, on the other question of state funding, I think that ought to be improved. And the law, if we enhance legal aid to a human right, it would increase state funding. We need to ensure equality of access to justice on legal aid so that it's available to everyone. Empowering consumers of legal aid in Kenya, that is a recommendation. And then I've said public and private sector collaboration is also important in the short term and in the long term in ensuring that legal aid works. But there's the big elephant in the room. How do we ensure that the quality of services offered by legal aid service providers is quality? Now, that is a challenge, because I know that the presenter from Strathmore Law Clinic talked about students providing legal aid to people, to the citizenry, and she talked about affordability. She's talked about the ability of students to flexibility on the part of students, and that's what I would call disponibility, because they're available to provide legal aid in centers. We tried that at the School of Law, Moi University, where we have legal clinics, we have legal externships that will allow students to go to centers and speak to the public. But you will find that amongst the students, a number of, and this also includes lawyers, would give wrong advice to the public. So how do you ensure that you do not have a student who himself has a problem with his assignments unleashed to the unsuspecting public to give inaccurate or wrong advice? How do you control that quality? Do we need trainers, develop TOTs or trainers to train these students to provide proper legal services? But again, there's a problem, because you cannot tell what kind of problem you will confront. And that would mean that perhaps the best way would be to allow students to work in teams, so that for every set of 5 students, you will have a Ronald Canalio Medal as leading a team, so that they can discuss the legal question and come up with a position that would make sense, and ensure that we also have lead faculty people or lecturers, or those who have, of course, we also have lecturers who have never practiced law, so there's a problem there also. Get those practical people who practice law to also be in the field with the student, because you also need to understand, we also need to know, we also need to have people who are, we need a few mechanics, out there, a few plumbers, legal plumbers out there with the students to be able to turn the theory into practical advice. And this I say from experience, because you have very good academic minds who are not able to solve some of the simplest cases presented to them. Of course, you also have very good legal minds who are not able to write the shortest paper available. I thank you very much, ladies and gentlemen. I've shared my paper. I hope that you'll find time to go through it and look at the comparative material that I have provided. And this is not just comparative. This is material born out of experience. This is an experienced hand on legal aid speaking to you this afternoon. Thank you very much, ladies and gentlemen. Unfortunately, I have to leave. There'll be no questions for me. If you have any questions, we can do that next time. Thank you very much.
All right. I will not say a word. Instead, I will invite the next speaker. So please bear with us. We're almost done. We have 2 more speakers. I'll call upon Ms. Jen Nyaga to make her presentation. And then the last presenter for the day will be Ms. Aska Josephine. Then we can break for lunch.
My name is Janet Nyaga. I'll be talking about the potential of traditional justice systems in ensuring access to child-friendly justice. So most of the speakers, like Justice Matheka, talked about the unique challenges that a child faces in accessing justice. So I'll only talk about the child-friendly justice systems and make a case for the traditional justice systems. So according to the United Nations Committee on the Rights of the Child, a child-friendly justice system is one that respects, protects, and implements children's rights, effectively implements children's rights. And unfortunately, our formal justice system does not meet this standard. We have seen and discussed in this conference challenges such as the inadequacy of legal representation, the harshness of these formal justice systems, which makes it hard for a child to actually access this justice. And so against this backdrop, I make the case for the adoption of traditional justice systems in resolving matters to do with children. And this is because traditional justice systems have several benefits, such as one, their legitimacy. These are systems which have been developed by the community to deal with the issues surrounding the community. And so people may respond to them better, unlike the formal justice systems, which were actually inherited by our forefathers from our colonial masters. This is what Ngugi wa Thiong'o, in his book Decolonizing the Mind, talks about disassociation with that which is closest to you and trying to form an association with that which is farthest to you. So rather than using the law which we have been using to resolve the disputes, we went for a law, for a legal system which does not respond to the unique challenges of the African child or of the African community. And so traditional justice systems may be more appropriate also. They are more effective in dealing with children matters. So in my research, I came across a study done of the Gusii community on how they resolve disputes. And in the Gusii community, if any person defiled a child, they had to pay a fine equivalent of a 6-month salary. Similarly, in the Embo community, should a parent or a guardian of any child be banished from the community because of maybe discriminating the child or abusing the child, the community will ensure that they will take care of this child. They will raise the child as their own. This will take care of problems such as institutionalization of children because of lack of guardians to take care of them when their parents are arrested. Similarly, traditional justice systems focus on rehabilitating an offender, a child offender, rather than punishing them and taking them to the harsh justice system. And so this will actually this will enable the society to realize the promise in the provisions of the Constitution that provide that a child should be deviated away from the criminal justice system. So the traditional justice system may help in attaining that. Similarly, they are more flexible and accessible compared to the formal justice system. Yesterday we talked about only 90% can access the formal justice system. And so traditional justice systems may be more accessible to children compared to the formal justice system. However, there are challenges with this kind of systems. For instance, the harmful cultural practices, such as early child marriages or female genital mutilation. But in dealing with this, the society can adopt can only selectively adopt the positive cultural practices and abandon the negative practices. There is also a challenge with the diversity because there are very many communities, which means that there are very many legal justice systems. All the communities have their own justice system. But one thing that we should recognize, all these justice systems have several fundamental principles which they all practice. So we can focus on maybe ensuring fairness, ensuring justice, and this will enable the community to effectively deal with traditional justice systems to deal with issues surrounding children, despite the challenges with traditional justice system. And so I'll make my presentation very brief because of time. And with that, I propose that we should adopt traditional justice systems in dealing with children matters because they are more responsive, they are more legitimate, and they deal with the unique challenges of our community. Thank you.
All right, thank you very much, Janet. Sorry, your name was misspelled here. We'll call upon our final presenter. It's a pity I don't know any sign language, but I think I'll make it compulsory moving now. So I'd like to welcome our final presenter before we break for lunch, and that is going to be Asker Josephine. Welcome.
Because we cannot communicate, myself and the interpreter. Good afternoon. My name, as you've heard, is Asker Josephine. I'm from an organization called FEDWIN, which is Federation of Deaf Women Network Kenya. Our title of the paper was about the voice of the voiceless, the dilemma of the voice of the voiceless. And we're looking at the deaf access to justice. FEDWIN is an organization that really represents the interest of deaf women and girls on sexual reproductive health rights. And I want to talk about on men. I don't know why you're wondering why from women and girls we moved to men, because this is what I want to deviate to. Because yes, we have really been focusing on women issues, deaf girl child issues and youth, but we have also remembered that the boy child has been vulnerable, and we've really forgotten about them because we went to school with them together, we've been interacting with them together, we see each other every other day. And when we advocate for our own issues, for the full success of our voice to be heard in terms of GBV and SRH, we realize that we need the men's voices, we need them on the table, so that they can look at us differently and also advocate for our rights. So before I continue, I want to give you a story, some of few cases that have happened that we picked that I can maybe help you understand our situation. So we have John, and these are not their real names. John is deaf. He never went to school. He's a carpenter. He went to a vocational school so that he can learn that vocational skill. And he doesn't know a lot of sign language, but he's very skilled in his carpentry work. And you remember when COVID broke out, the government introduced the curfew. So this man was from his job, and he decided to go home. You know, people knew 7 p.m. you need to be at home. So this guy didn't know, and he went home. So when the police were walking around, they were like, you stop there, you stop here. But because he's deaf, he wasn't hearing. So they assumed he was arrogant, and they approached him and they really beat him, and there were so many cuts on him, and he really bled. And he was thrown into the prison. But one person who saw this incident went to the police station and said, no, this guy is deaf, and I'll take care of him, I know where the family is. So the police were very shocked. The Samaritan took him to the family, they went to the hospital, and of course, you know, we did not know how to receive justice because he was thrown into the police. He will come to the same police station where the same police officers had done this injustice. So we thought we know that we have a fear that as deaf people we will die sooner than the others because of such happenings. Another story. Robert is deaf. He is a father of 4. The problem of him, alikuwa na mpango wa kando. He fell in love with somebody else, and they continued. So what happened is, his side hustle chick had another man. And this deaf man, Robert, really had a good job. He had good money, and the lady was attracted to this. This lady is hearing. So what happened is that he also used to take care of this girlfriend who has a daughter. So he'll buy her sweets, buy her all these things. So one day he passed on the shop as is usual and gave the girl the daughter and went home. But the girlfriend went to report to the police that this Robert deaf guy had raped the daughter. So Robert was arrested, and there was no interpreter, so he didn't even know what was happening and what was going on. So he was from the police station, he was told that he has to go to committee for 5 years. So of the deaf community, since we are small and we knew of this issue, we decided to look for a private lawyer, we contributed the money, and we went back to court, and we discovered that, of course, it was an injustice. He never raped his daughter, there was no evidence, and now this man is out after 5 years in committee. My last story. There's a girl who's intellectually disabled as well as deaf. So, you know, sometimes the girl has been left at home for the parents to go and look for food. The neighbor was like, there's nobody here, and decided to rape this girl. So what happened is that this man was not even arrested because it's something that he did with the police officers. We're not sure that there was a bribe, but when I heard about this, because our organization is well known, they contacted us, and we saw that, you know, the interpreter who was appointed there did not know that this girl had 2 disabilities. She was not able to understand how to really have the needs of this girl addressed. So when we went to the court station, I went there to the police station to see what was happening. We really advocated for everything, and I had a good lawyer had a good interpreter with me, and we were able to tell that, you know what happened, this is what really happened, and we were showing, we had the evidence, we collected stories from the neighbors, and this man really knelt in front of the police station asking for forgiveness and crying, and justice was served. So we also have a story of Charles, because he had an accident and his leg was amputated, and he's deaf, so there was no way he can have his crutches and sign at the same time. And this is also some of our disability. Sometimes you are deaf and you have also another additional disability. And in his case, he's never had justice in terms of that accident because it was something he could get readdressed. So for the deaf, people feel ignored and marginalized because the court justice system is not accessible and it's not deaf-friendly to us because we need the services, but we're not getting served like the others. You've all talked about the Constitution and the article that talks about human rights, but I hope you're aware that the Constitution also says that Kenyan Sign Language is the 3rd official language in Kenya. And we wonder, why can't some of us learn who offer the basic services, and therefore the deaf can be able to access services at all times instead of saying interpreters? Yes, I've heard that the courts are saying they have interpreters. Like myself, we're based in Nyeri. We don't have a court interpreter there. We need to come from Nairobi, so any of our cases there need to be postponed or rescheduled. So we need you to know that not all interpreters can understand one another. So for example, I understand Sylvia, maybe another interpreter will come, I may not understand them, because also for the deaf, maybe they don't know sign language, they use traditional one, and you bring this proficient sign language interpreter, there is no communication. You need to understand that I can sign. So in such situations, you need to understand that there should be a need of a deaf interpreter in such situations. So there are so many issues that need to be taken into account. Sometimes deaf people are arrested, like you've heard, but if you're cuffed, you cannot communicate with your hands. How do you expect me to answer? That's all I do when I'm cuffed. There's no communication, it's really hard. So you're cuffed. Even if you don't cuff them, they'll not run away. Just have two people beside, let them sign. You know, some even cannot write a statement because they might be illiterate, and you're forcing me to sign, and you're telling me to write something I don't know. So maybe let a competent interpreter show up, and then let me know what I do, then I can write the statement, then forcing me to write what I don't know. So like for now, if a person has been arrested and go to police station and they go to the court, there is no interpreter, and you know when they're talking about me, I don't know what they're saying. I feel it's not right because we feel oppressed and discriminated against. This system needs to be improved and to be friendly to the deaf people at the police station centers. Also, we have deaf children. You know, maybe a good Samaritan finds this deaf child, they take them to the police station, and then they're taken to the children's court, and then they're taken to rehabilitation centers or remands, and they cannot communicate. Like you've had, there's no special needs education for them, and they forget. And then when they're released out into the world, that's the end of them having a meaningful life. We have compared what happens in other developed countries, like in Europe. We have seen what happens, like if there's no court interpreter available, there is the visual tools, it can be online, and everything is solved, which is now faster access to justice. So maybe these are the best practices we can solve as the judiciary of Kenya to see how justice is accessible to the deaf person. For example, you know, most of you have put a ramp, but I'm a deaf person. I appreciate you have a ramp that my brother or sister who has a physical disability has accessibility, but it's not for me. So we did a survey as a Fedwin organization, asking them a question whether they believe in the justice system. 90% of the deaf said no, and 10% said, yeah, not 100% sure, but yeah, it's there. And the second question that we asked during our survey, when do you feel like when you're accused of something, you'll get justice? 80% said no. Some said yes or no. Others said no because they thought, you know, maybe I'll hear this interpreter, I'll get there, but they're not sure of the other barriers that they will face and challenges that they face, because we know that, yes, the law is for everybody. The National Legal Aid Act says it's accessibility for all, but we need this to be more clearer on how this can be more accessible for us as a deaf community. So there are many, many cases where deaf people are arrested for nothing, wrongfully accused, they're arrested, and then later, sometimes if you follow up on that, you find that, yes, there's no case against them and they're acquitted. The Legal Aid Act, Section 5, says provision of services to people who are marginalized, vulnerable, and all that. But I feel that it needs to be clearer on what that exactly means. It talks about promotion of legal language and awareness. We need this because in the morning I'm really happy that Mrs. Bidali approached us on how this can be more accessible to our deaf community. And also the National Legal Aid Service Fund on Justice, advisory centers and all these things, we are not able to access these provisions that are already outlined. Promotional of the use of different centers, these methods, and enhancement to access to justice, we hope that things will change for us to benefit as well. We have all these different provisions, and I hope that now you'll fully address it when it comes to the deaf accessing justice and other persons with disabilities. And to tell you the truth, there are not many justice intervention measures. Our organization is really trying to do this whenever we hear of such cases, But we believe that from the networks that we've received from today, we believe in partnership and collaborations, that these issues will be resolved going forward. The judiciary system, from the police officers to the magistrates, to the lawyers, to the paralegals, to the prosecutors, and all other stakeholders involved, is very complex for us. And we feel it's really close to us. We hope that they can be open to us, they can understand our culture. And before I conclude, I said in the morning that we've already talked with Madam Flora Vidali. We really discussed something very interesting, and she said from going forward, we will work together so that we can create deaf awareness in different countries so that these services will be closer to home. And I'm really looking forward to that there is a light at the end of the tunnel for all. Thank you for listening to me. You can't clap. You cannot clap.
All right. Thank you so much, Aska. We appreciate your insights on what you go through, and I'm sure all of us now have a better understanding and appreciation of some of the challenges that people around us face. It's at this note that I will close this session. Of course, please keep the questions that you have. Let's proceed for lunch. I think 30